next matter to be heard today is Jackson versus Ohio Department of Education. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning, and I can keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
Good morning, Your Honors. May it please the Court, I am Richard Kudachev. My client is Willena Jackson. Your Honors, we're here today, and you know, I forgot to reserve my time, so I'm going to ask for 3 minutes for your rebuttal. So why is it that lawyers have this love-hate relationship with an administrative matter, with an administrative appeal? I think as lawyers we are so OCD, we're used to process, we're used to procedure, we're used to certainty, and that's not what we find in the administrative agencies. There's some uncertainty, some looseness, but this court today has a great opportunity to define more clearly the process required for notice and how to comply with due process and fairness. Unless otherwise provided by law. I'll ask the court to take note of that phrase as I discuss it through this time. How do we provide a fair method of notice? How do we come to notify Ms. Jackson? Notify Ms. Jackson. That's the resolution of the Ohio Department of Education, Your Honors. And the question is, did they notify her and when they did? We can correct an injustice today. This court can correct an injustice by defining notice requirements. In this instance, my client was sent a letter from the Akron Board of Education back in 2012. It was sent to P.O. Box 2426. In June of 2012, another letter was sent from the Department of Education regarding disciplinary action. A notice of opportunity was had. Proceedings were had at the Department of Education that are not relevant here, and the board ended up adopting a resolution on September 16, 2014, denying my client's 5-year professional elementary teacher license. Now, the resolution is of critical importance. You know, as a board member with the Coventry School Board, I have some inclination how boards act. Boards speak through their resolution. It is clear, just like courts speak through their orders. In this instance, the board said that the state superintendent of public instruction be, and he is, directed to notify Ms. Jackson. The resolution was not sent by the superintendent, but somebody named Lori Long, the director of professional conduct. It was not signed, notated by Dr. Ross, the superintendent. He's not involved in the notice in any way. Further, Your Honors, as you look through the resolution that was sent to my client, it is incomplete. The resolution does not indicate who voted, when the vote was taken, how the vote was taken, what the vote was, what the roll call was. The letter was sent to some Longview address, not the P.O. Box. It was sent certified mail, but not delivered to Willena at Longview until October 18th, and we're not even certain who signed that, but we do know that on October 29th, within 15 days of the 18th of October, my client did file a substantial compliance for a non-lawyer, a notice of appeal with the board and with the Summit County Court of Common Pleas. The record was filed, and on January 16th, the court below, the administrative court, dismissed the matter, claiming in the order that there is no jurisdiction because of late filing. Your Honors, the standard of review in this case is critical. This is not a merit case. This is strictly a procedural issue on the dismissal. The standard of review, therefore, is an error of law, abuse of discretion standard. This court would not be substituting judgment in any way or form by ruling that the court below erred in accepting jurisdiction. This court is not interpreting anything from the board, the Department of Education in any way. So this is strictly a administrative, substantive resolution that is at issue only by process of notice, not by the substance therein.
So
Well-
you're saying that our review is de novo because it's a legal issue?
It is de novo on the issues of law only, not on the issues of substance, Your Honor. You know, we have two statutes that have to be looked at. Revised Code 119.12 talks about a notice of appeal to be filed within 15 days. And after the mailing of the notice, after mailing of the notice of order, and then you have those magic words, as provided in this section. Your Honors, look in that section. There is nothing that talks about service. That's why this court, the law must be read in conjunction with 119.09 that talks about service. There's no provision in 119.12 for the nature of mailing of service. So those two sections must be looked at together. The statute requires that certified mail service occur. Now, isn't that the fair thing? Let's take a look. Isn't it axiomatic in the law that service be made? Come on, when we file a lawsuit, service has to be made on the defendant within a year. I mean, if not, you have to have service, and it has to be by certified mail. The mailing of notice is a condition precedent, but it must be by mail, by certified mail, return receipt requested. It requires notice in a very particular way. In an old case, ISO v. Clem from 1978, the 10th District, the only citation I have is 1978 Westlaw 217044, followed this type of rationale, which only makes sense. Your Honors, what's fair in this case? In this instance, another thing occurred that just isn't right. As I mentioned, a board speaks through its resolution. The decision of a board must be in writing. It must be reduced to writing and approved. Now, how do we approve a resolution? In my day on the school board, when we made a resolution, we had a vote. It was then reduced to writing. It was then entered into the journal. Then it becomes an order, just like in this Court of Common Pleas. Now, in this resolution, Your Honors, what does it say there? It says very clearly, and let's take a look at 119.09 for a second. It says, the agency shall serve by certified mail, return receipt requested upon the party, not the lawyer, a copy of the order. Now, if you look at the resolution, the journal, first of all, by the board's own admission, is not ratified until the next meeting. So therefore, you don't even have a valid resolution until ratification. It just can't be. That motion, that resolution has to be ratified and signed.
But what is the purpose of the notice? Is the purpose of the notice to inform the teacher that the board has taken action and what the action is? Because you've gone on to argue that in addition to the notice of the board's action, that the minutes need to be attached and information that we would, in other contexts, suggest that you could get through discovery or there would be another means of obtaining. But explain why it is that, first of all, what is the purpose of the notice? And then two, why is it that you claim that minutes need to be attached?
Well, I did not claim the minutes have to be attached, Your Honor. That is...
is that not a part of your
No, Your Honor, not at all. That's sort of something the board advances as a red herring, in my opinion. What needs to be attached, however, is the complete resolution. I ask you, when you're looking in the record, look at page 416 and 417 and 418. That is what is sent to Willena. Okay, now, if you look at the record, page 380, 1 and 2, now you have a full copy of the resolution, not the minutes, Your Honor, but you have, be it resolved, it was moved by, it was seconded, a roll call, the votes. Now you know who's voting, what, when, and where. Just like a court order, you know what's happening. Then it says the motion is carried. That is what a complete resolution is, just like a complete order. Now, who can send that out? Your Honors, take a look at the resolution by the board's own directives. It said the superintendent is to give notice. The superintendent is directed to notify Willena. How simple is that? So if you want to take a technicality, we'll just put a mailing in. And if it happens, if we have the right address, if we don't, all of that is unfair. Who is the director of Office of Professional Conduct that sent this letter? I don't know. You can't just delegate authority. The board's going to say the superintendent can delegate it to his assistant. Can the judge in the Court of Common Pleas delegate to his or her bailiff certain duties? No. The law says the clerk of courts has to issue an order, not the bailiff. It's frivolous to conclude simply depositing in the mail without looking at the requirement for service is appropriate to trigger. And you put that next to the fact that the resolution was not delivered appropriately by the board's own resolution through the superintendent. That's why administrative appeals are so difficult for us lawyers. There's uncertainty. The certainty is the superintendent's supposed to sign, he's supposed to send the whole resolution after it's ordered and entered into the journal. This is a denial of a license, her livelihood. The superintendent is the person who hires and fires in the big scheme of it. That is the person who needs. Just like the judge. The judge is the person who signs an order, not even the magistrate. That is why it's so critical for this court to decide and make clear when you issue a 15-day appellate review in an administrative case, it has to be served in conjunction in this particular type matter with certified mail service. Even though the board says there's no statutory duty for the superintendent to do this, who gave him the duty? The board itself. The duty was coming from the resolution. And that's of critical importance here.
And Counsel, you're just now reaching that 3 minutes.
Thank you, Your Honor.
Good morning, Your Honors. Jennifer Bondurant, Assistant Attorney General here on behalf of the Ohio Department of Education. Your Honors, Ms. Jackson does not make any arguments here that she didn't make in her brief. We fully addressed those in our brief in great detail. There are so many arguments that were thrown at us that of important note were not raised at the trial court below. The trial court followed the clear precedent, long-standing case law in this case in its reading of 119.12. Revised Code 119 has various time methods. At one point in the statute, the receipt by the educator is of importance. Here, the legislator made very clear that it is the time of mailing that triggers the 15-day timeline. Ms. Jackson simply did not file her appeal within that timeline. The resolution is complete. The board followed the law and how it served it. There is simply no support for Ms. Jackson's position that the superintendent could not have one of the staff members, the director of the Office of Professional Conduct, actually mail the resolution.
Well, she can just mail it. She signed it, right?
She did sign it. She signed it just like I signed my name under Mike DeWine as a staff member of the Office of the Attorney General's office. The statute makes clear, this is detailed in our brief, that the superintendent or his designees may sign the resolution, not the resolution, sorry, may mail the order. And the statute for the Ohio State Board of Education also lays out what the duties are of the Department of Education. It is the arm of the state board that carries out its responsibilities and duties. The Office of Professional Conduct is the part of that arm that serves the resolutions. This is what happens in every other agency, the licensing agency all over the state, and we simply there is simply no support for Ms. Jackson's position in this case.
What about the argument that what was said was not a resolution or an order in the agency, regardless of who signed it?
That is the first time I've heard it put in that way, and I don't have the two documents in front of me. I urge you to look at them. When I was writing my brief, did study them in depth, and I believe that the resolution is complete with what was required by the statute. In his brief, he argues that the minutes, essentially the minutes had to be included. The statute differentiates between the order and the journal, and it would simply be very inefficient for the agency to be required to send its entire journal for each order every time it enters an order. It would include the minutes. It isn't ratified until the next board meeting, which usually is the next month, but could be 2 months. So it simply flies in the face of what is efficient for the agency to do, and there is just no support for the position that that entire journal must be sent. The statute says order. Any other questions, members? Thank you.
You have just under 3 minutes remaining.
Thank you, Your Honor. I think the clarity that we're trying to make is the certainty of what needs to be said in the order that makes an extraordinary impact upon an individual. Nobody is talking about the minutes again, as Judge Moore astutely addressed. That is not the topic. If we were to send an order, a court order, to a party that was not signed by the judge and did not indicate a decision or did not say it's a final appeal or it's incomplete, if you look at the record that was filed here, and I think there are some problems because I don't think they're labeled as exhibits, that's why I gave you the number, the page numbers. You're going to see what I'm talking about as I very clearly defined in my appellate brief. And in regard to not raising things below, it was the Board of Education that raised all these issues we're talking about today. These issues were raised there. There is no compulsion for Ms. Willena Jackson to file a reply to this motion to dismiss in order to raise issues in this court, because the board itself raised those particular issues. It is important that I also point out to you this, Your Honors, when a superintendent makes an order where a resolution is defined by the board, and the superintendent is the individual compelled to carry that out, that individual cannot delegate it to some unknown named individual who is part of the whole process. And as Attorney Bondurant may have suggested, her assistant signs things for her, as does mine. But you know what my assistant does not sign? Ever, and that is a pleading. Only a lawyer can sign a pleading, and just like as in this case, only the superintendent can sign the documents necessary. In this instance, notice did not occur properly. Notice was not served properly. My client's time for appeal has not yet run. And so I'm asking this court, scrutinize those two statutes very clearly, because you have a unique opportunity. There's not a whole lot of case law here. Demonstrate. All it is to say you got to file within 15 days. You have a unique opportunity, Your Honors, through this case to make a definition across this state as to what is fair and what is appropriate for due process and the constitutional rights that an individual who is going to lose their teaching license should have, so that they can preserve their right to appeal from an administrative agency that we as lawyers have OCD problems with.
Thank you, counsel. Thank you both for your presentations today. The court will take the matter under advisement, which will be issued, a written decision which will be issued to both sides, as well as posted on the Ohio Supreme Court website. Thank you.